Thanks so much for being here. My name is Marcy Koski, and I'm the leader of the firm's National Consumer Financial Services practice. First, we'd like to apologize for the technical hiccup that we had last week, and we're really grateful that you joined us again today. I'm based in beautiful Madison, Wisconsin, where the sun is shining. And last week, I had a fun quip about how even though the sun was shining, it was 20 degrees. Today, I'm happy to report that it is going to be somewhere in the highs of the 50s and 60s. So absolutely gorgeous Wisconsin weather. Let me tell you a little bit about our consumer financial services practice. It is a practice that is part of a full service firm, and it has its own full service offerings. We have a strong expertise in both federal law and state laws across the country. In the three-legged stool of consumer finance, we use that expertise to give clients practical compliance advice. We represent them in single plaintiff and class action lawsuits and defend them in every stage of an enforcement action. Our clients are all types of companies and financial institutions in the consumer finance ecosystem that deal with all kinds of issues, big and small, whether relating to the most complicated of state laws and challenging state regulators and attorney general to federal laws in the CFPB, whether led by a Democrat or a Republican appointee. Before we begin, I'd like to give you a few housekeeping instructions. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions during the webcast, please submit via the question box. We will try to answer all of the questions during the webcast today, but if a fuller answer is needed or we run out of time, it will be answered later via email. A PDF of the presentation is available in the program materials folder. Auto-generated closed captions are available for today's program. To turn on closed captions, click the CC button in the bottom right corner of the medium player box. This program has been approved for legal education hours. For live attendees, report your hours by clicking on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Towards the end of the program, be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. All right, that's all for housekeeping items. Let's get started with our program. Today, we are going to be exploring what is going on with the CFPB. And alongside me, we have three speakers. The first is Ryan DiClemente, who is a partner on our team. He has worked hand in hand with our enforcement colleagues, including John Redding, on a number of state and federal enforcement matters over the years. Ryan is a recognized litigator entrusted with the management of regional and national client portfolios. Ryan counsels and defends finance companies and financial institutions against complex claims raised by consumers and enforcement agencies that arise from both federal and state consumer protection laws. We also have Mike Silver. Mike, who worked for more than a decade at the Consumer Financial Protection Bureau, where he played a central role in writing some of the agency's most impactful rules and guidance. Mike advises the firm's consumer finance clients on a broad range of regulatory compliance matters. Mike served under multiple presidential administrations with differing agendas, so the current state of the CFPB is of particular interest to him, enabling him to provide insightful thoughts on what could possibly be next. Last but not least is Chris Friedman. Chris Friedman is a nationally recognized thought leader in fintech, consumer finance, and alternative commercial finance, serving as a go-to legal advisor for companies navigating the complexity of the financial services industry. Chris has a knack for distilling complicated federal and state regulations into actionable compliance advice. With that, I think I'm handing it off to Chris.
Wonderful. Thank you so much, Marcy, and happy to be here. Happy to see everyone joining today. What we're going to start with is just a recap of where we've been over the last few months. I know it's been a bit of a madcap journey. And there's been a lot that's happened. So we're going to kind of do a little bit of a tick-tock through what has happened before we move on to some of the updated items and our kind of updated thoughts with regard to what's happening at the CFPB. So with that being said, I'm going to quickly kind of go through where have we been. And I think the first thing to keep in mind is that, and I remember how interesting this was, that former CFPB director Rohit Chopra lasted 10 days, which was kind of 10 days longer than anyone thought he would last. I don't know if anyone remembers back in 2022, there was kind of a meme about British Prime Minister Liz Truss versus a head of lettuce, and which would last longer. I think that came from a British tabloid, and I think that the head of lettuce lasted longer than Liz Truss. Well, we kind of had the same kind of meme here, and I'm sure other people thought the same. But he did last 10 days, but unsurprisingly, on January 31st, Director Chopra was replaced by Treasury Secretary Scott Bessent. And he very quickly ordered the CFPB to stop all rulemaking, communication, litigation, and other activities, according to an email that was leaked. The only activities that were allowed to go forward were activities that were authorized by Scott Bessent or required by law based on that email. The email also called on the CFPB to suspend the effective dates for all final rules that hadn't taken effect yet. So the rules kind of affected by that rule would be, or that directive would have been things like the ban on medical debt, on consumer medical debt on consumer credit reports, and the $5 cap on overdraft fees. And then the email ordered the CFPB not to approve or issue any new proposed rule or a final rule or formal or informal guidance. And then pending litigation was paused. The CFPB, appearing in the Fifth Circuit, requested a continuance, allowing for the leadership to review litigation. So what we really saw was kind of a pause on anything that was happening. But if you will recall, there were some rules that were in place with effective dates that had been published in the Federal Register, and it was a little more unclear as to how you might approach some of those issues. Now, on February 7th, Russell Vogt was placed as CFPB director. As you might recall, Russell Vogt was kind of one of the architects of Project 2025, and he expanded that freeze to cover things like supervision and exam activities, and then shut down the CFPB's headquarters. He also cut the agency's next funding request to the Federal Reserve to $0. This happened apparently on the same day that Elon Musk's Doge, Department of Government Efficiency, got access to the Bureau. So what you saw then was kind of with Scott Bessent was kind of the beginning of a slowdown. And then with Russell Vogt, really an aggressive halt to really anything that the CFPB was doing. I mean, yes, the CFPB existed as an entity, but for all intents and purposes, it just stopped when Russell Vogt took over. And some of the things we saw, I think most notably, in terms of those looking to read the tea leaves, was that dozens of contracts that were essential to the funding of the Bureau were just canceled. And you saw, if you followed kind of what was happening on social media, a lot of third parties that held contracts to do things like offer expert reports for CFPB litigation. They were saying, hey, our contract was canceled. And that really, for folks that were following it, that indicated a real substantive kind of slowing or halting to all things CFPB beyond just the surface level. So that's kind of where we are now. I'm going to throw it over to Mike Silver, who's going to talk about some of the litigation related to some of those, some of the things that happened with regard to kind of stopping the CFPB as an entity. So Mike, take it away.
Yeah, thanks, Chris. And glad to be here with all of you. So I'm going to go through a very important lawsuit that has been pending in the federal courts in the District of Columbia for about the last 6 to 8 weeks. And this is kind of the tail end of the TikTok that Chris was going through in terms of the transition from former director Chopra to the very briefly acting director Scott Bessent through the current acting director Russ Vogt. So the week between February 8th and February 14th is really the heart of what's at issue in this lawsuit. And just to step back, the parties, the NTEU is the National Treasury Employees Union. That's a labor union for federal employees that has a chapter 335 at the CFPB. So they, along with several other plaintiffs, including the NAACP, the National Consumer Law Center, the Virginia Poverty Law Center, and several others, have challenged the actions of the Bureau that took place during that period in early February. And I'll get into more of the specifics as to the why and to what has happened in the courts so far. But essentially, between February 8th and February 14th, when Vogt took over, Chris had mentioned the initial emails from Bessent, which basically put a freeze on pending work. Well, Vogt went further and issued what really was a stop work order for the entire Bureau. And then there were, as Chris mentioned, there were contracts that were being terminated. And then allegedly, and this is, again, the heart of the lawsuit, the Bureau leadership was attempting to execute a mass reduction in force of about 1,200 people that would have come down on February 14th. And so basically the employees union went to court in federal district court to try to get an injunction to block that mass RIF from taking place. And so that is what happened that's what this first slide is describing. So they had filed an initial complaint a few days before, but then they filed an amended complaint, alleging basically that, and I'll just advance the slide to capture a little bit more of the issue. Alleging that the CFPB was engaged in a shutdown effort to basically, through a collective set of actions, stop the Bureau from operating and stop the Bureau from functioning, and basically reduce it to a nullity in contravention of Congress. And so basically there was a lot of procedural stuff that happened. Judge Amy Berman Jackson in the district court agreed to convert it from a motion for a temporary restraining order to a motion for a preliminary injunction. The parties agreed to a pause of certain activities like destroying data and any sort of mass terminations. And then there was a period of time in which the docket was set up and emails were being released by the parties to complete the factual and evidentiary record. Now, just trying to make sure I'm on the right slide here. Okay, so a very key issue emerged during this period between February 14th when the NTEU went to court. The judge agreed to put a hold on things temporarily while the proceedings were going ahead. And it basically, initially, the CFPB, through their chief operating officer, a person named Adam Martinez, was asserting that everything that was happening, all the stuff that Chris mentioned a few minutes ago, and everything else, including this, alleged RIF of 1,200 people. And by the way, the CFPB has about 1,500 employees. So 1,200 out of 1,500, that's 80%. And they also had previously terminated about 180 employees. So now you're talking about, leaving 10 to 15% only of the Bureau employees in place. So this is a truly mass cut. But nonetheless, Mr. Martinez was asserting in a court file declaration that this was all normal. This was all just part of typical agency transitions. And that, it was a common practice for there to be a pause, for there to be a stop work order, and even for some of these other things to take place. And they were maintaining through his declaration that the CFPB was, and this is again key to the lawsuit, that they were fulfilling their statutory obligations. The union then filed a number of declarations that countered the facts that were asserted in Martinez's declaration. They had some people under pseudonyms, they had some people under their actual names, and they basically were executives or high-level staff in the different functional units of the Bureau who were saying, okay, this declaration says the consumer response function, for example, is fully operational. That is not true for XYZ reasons. And so they went through that. So, and again, this was supplemented by a number of contemporaneous emails that were released by both parties to sort of flesh out the evidentiary record. Now, just to step back for a second, what in a sense has been typical, at least going back to the first Trump administration, and we saw this under the Biden administration, is that early in a transition period, there's a lot of disruption. And when that happens, you will often see lawsuits filed by the policy and political opponents of whoever is in office at that time, and they typically will file suit in what are perceived to be favorable jurisdictions. So there was a lot of litigation in the DC circuit in the first Trump administration, and some of it was successful at stopping various executive orders and other actions. Some of it wasn't. And then, the inverse happened under the Biden administration, where a lot of actions were filed in the Fifth Circuit Court of Appeals in Texas, which has been more favorable to, conservatives and to opponents of the Biden administration. So I think we all expected that there would be kind of a snapback to some of this dynamic where early in the Trump administration, part two, there would be a number of lawsuits filed in DC, and they might initially get traction given the composition of the court. And I think one of the things Marcy and I maybe we'll talk about later towards the end is contextualizing, what this all means in terms of, what happens with the CFPB afterwards, and also kind of what it means for you all in terms of your operations. But I think one of the key points here is that some of what is happening is really typical and kind of mixed with these other trends and dynamics in terms of, planned cuts at other agencies, like you all have read in the news, or maybe even know people who were affected personally by cuts at USAID or at the Department of Education, or most recently, Department of Health and Human Services. There's just a real push to have, through the DOJ, to have pretty significant cuts at a lot of different federal agencies. So I think some of what has been happening at the CFPB is really intertwined with that. At the same time, a lot of it really is unique to the agency and its history and the fact that it's been in the crosshairs since the very beginning. And again, this is kind of backdrop for this particular lawsuit. So getting back to the specifics, so just to move one slide ahead, because of all the facts basically being in dispute, on the one hand, the CFPB through its chief operating officer saying, there's nothing to see here, everything is fine, everything is normal, we're following the law. And then the union is making all these assertions that is not the case. So the judge basically threw up her hands and said, we need to have an evidentiary hearing to get to the bottom of this, because she wasn't satisfied by what she was seeing in the particular filings. So they had two evidentiary hearings. One was on March 3rd, and the other one was the following week, and that ended up being a 2-day hearing. Martinez himself was put on the stand, and he was questioned by the judge. He also was cross-examined by the counsel for NTU. And a lot of interesting information came out during those evidentiary hearings. And frankly, based on the opinion, which I'll get to in the next slide, a lot of it was unfavorable to the government and really kind of backed up the version of the facts that had been asserted by the union. And just to highlight a couple things, so Martinez basically corroborated that there was a plan afoot to fire nearly all of the CFPB employees. It would have been in two phases, 1,200 employees on February 14th, and then another phase, which he even admitted would have affected himself. He would have been fired in the second phase after that. There was an email that came out during the release of the emails that had a colorful reference to the possibility that the Bureau would be reduced to, quote, 5 men and a phone. Now, just remember that phrase, 5 men and a phone. I mean, we could have a separate discussion about the gender aspects of that phrase, but that was, at least in the eyes of whoever wrote that email, was understanding what they perceived the goal of this effort to be. And then there also was evidence that came out during this hearing that even with the court order in effect starting on February 14th, that there still were meetings happening through the Office of Management and Budget and the Office of Personnel Management that were basically planning meetings to execute the reduction in force. So let's get to the opinions. So on March 18th, Judge Amy Berman Jackson issued an opinion, and sorry, March 28th, my mistake, and she granted the preliminary injunction that the plaintiffs had asked for. And it was a very long opinion. It was 111 pages. And she went through all of the various factual pieces that I've been, high level summarizing here. She found that, and again, the standard for a preliminary injunction looks at whether there's a likelihood that the plaintiffs will succeed on the merits and how that balances with certain factors like whether granting an injunction is in the public interest. And she found that all of those factors were in favor of NTEU. And just to paraphrase some language from the opinion, plaintiffs were likely to establish that the administration violated separation of powers by engaging in an orchestrated plan to eliminate the agency quickly and non-statutorily, and that without the preliminary injunction, the closure of the agency will be swift, complete, and irreversible. And then she focused on how the stop work order that Chris had initially mentioned on February 10th really was the end of a decision-making process that had concrete legal consequences. One of the arguments made by the government was that it wasn't final agency action. And then paraphrasing some more language, consideration of the record as a whole, the court finds it is likely the plaintiffs will succeed. The defendants were engaged in the concerted, expedited effort to shut the agency down entirely. She used some very strong language. It really was pretty extraordinary. Some of the characterizations of particularly Martinez's testimony. She likened it to an abused wife brought to court by her husband to drop the charges, commenting on his demeanor, how he seemed to be betraying what he had written, with kind of giving off a vibe as if he really agreed in a sense with the factual record asserted by the plaintiffs. Talked about, in her view, the defense collapsed like a balloon at the end of the Macy's Thanksgiving Day parade. That was memorable for me growing up in the New York City area and one time going as a child to that parade. But then this all went to the DC Circuit. Okay, so it was appealed by the government very quickly. And this is all happening exceedingly quickly for a procedural process in court. And they had a hearing last week, and there was another order issued on late Friday. And so this also goes to the fact that we rescheduled the webinar, and things on the ground have changed even in some significant ways. So where is the DC Circuit on this? They basically split the baby. They agreed in part with the district court judge. They agreed that certain of the things that she had ordered to be stopped, including the contract terminations, the consumer response functions, that they needed to go back to normal, preserving all data, no data deletions, and allowing employees to have access to systems and computers and space to do their work. All of that was kept in place. The government had asked that on appeal that all of it be wiped out. However, the appeals court, it's a 3-judge panel, they did agree with the government in the sense that they thought the district court judge's opinion was overbroad. The terms of the injunction were overbroad in terms of their ability to execute a reduction in force. So they did allow for space for the CFPB to execute reductions in force, provided that they make, quote, a particularized assessment of that the positions are unnecessary to statutory duties. And one of the things we'll talk about as we get into this more is this is really the elephant in the room with this case, which neither side has really fleshed out completely, and there hasn't been a judicial opinion on yet, which is what are the quote unquote mandatory or necessary CFPB statutory duties. The government is trying to minimize that. The NTU, of course, is trying to maximize it. The truth is likely somewhere in between. And with that, I will turn it to Marcy, I believe, to talk about another important development on the confirmation of a permanent CFPB director. Oh, but before that, I realize we have a poll question for purposes of continuing education. So very simple question, will the NTU prevail? Yes or no? Still, I'm not seeing any submissions, so I'm not sure if I didn't do something I was supposed to. Oh, looks like we're now getting some poll submissions.
Chris, you forgot to put an "it depends."
That's usually the answer.
Yeah, that's a cop out answer.
Yeah.
This is the forced choice,
Marcy. Pick a side. All right, I think we have a critical mass, so I will move on. Oh, looks like we're pretty split reaction here. So I think this shows that this is a tough one. All right, turning over to you, Marcy.
Okay, thanks, Mike. As you were going through that, I was thinking, is this going to be the next legal thriller that we're going to see released on Netflix? And if so, who's going to play who? So let's keep that in mind here. All right, let's talk about the appointment of Jonathan McKernan. So look, whoever is the director of the CFPB has a strong influence on the personality of the CFPB. So who is Jonathan McKernan? So first of all, he is a former consumer finance and banking regulatory attorney in private practice. He's at Wilmer Hale and Hogan Lovells. He has described his experience at those firms as overseeing large teams investigating compliance issues at complex consumer financial companies. So he does have some very on point and direct experience. He, as noted on the slide deck, has held staff roles in the Senate, the Department of Treasury, the FHFA, and he also had a short stint with the CFPB. Over the past 2 years, he has served as a member of the FDIC's board of directors. So what has McKernan said about the CFPB? So he released a statement that he believes the CFPB has acted in a politicized manner, pushing beyond its statutory authority and offending basic notions of fairness and due process when it has regulated by enforcement. This is consistent with what we've been hearing and thinking about when we knew that Trump won the election and it would be a Trump 2.0, that we anticipated a diminishment in regulation by enforcement. And so McKernan's statements certainly are consistent with that. McKernan has said, though, that he will faithfully and execute the law, that he under his watch, that the agency will take all steps necessary to implement and enforce the federal consumer financial services laws and to perform its other statutorily assigned functions. Now, remember what Mike just said, which is what exactly are those statutorily assigned functions and how is that duty met? How much of the statute, how much work has to be done to fulfill the statutorily assigned functions. Now, the director certainly has a huge and strong influence on the CFPB, but at the end of the day, McKernan will serve at the pleasure of the president. So he is answerable to President Trump. So regardless of his background or his personal views, President Trump will be his boss and he will take cues from the president. And as we predicted, or some of us debated in a webinar that we had a couple of months ago on what enforcement would look like under Trump 2.0, I think we are safe to say that Trump 2.0 is certainly looking different than Trump 1.0. The vote on McKernan has not yet been scheduled, but at this point it is looking like it is going to be in May. With that, speaking of enforcement, Ryan?
Yeah, thanks, Marcy. I really appreciate the opportunity to talk to everybody today. This is, as many have noted, a really evolving, interesting topic that literally continues to evolve by the day. So I'm going to cover what we've seen on the enforcement side since the change in administration. At a very high level, I think you've heard from others, you'll hear from me. I think it's fair to say that some of what we've seen is expected and normal with the change in administration, and some of what we are seeing is certainly new and novel. As a general matter, a pause in enforcement activity during a change in administration is common, while the new administration evaluates and sets priorities. To date, the CFPB has gone a step further than prior administrations and has been more aggressive in actively dismissing pending cases, which we'll talk a little bit about. There have been some recent indications, however, that certain enforcement activities are starting to wake up a bit and proceed with pursuing targeted areas of enforcement. However, until there is a permanent director at this point, and the director has been confirmed and has an opportunity to set priorities, we are likely going to continue to be left reading tea leaves and speculating. So, as I mentioned, the CFPB has rolled back its enforcement docket significantly and dismissed, at this point, 11 active cases. We've listed these cases here, and you'll see that they include a variety of different claims and a number of different types of companies. Some of the public statements and our own interpretations are that these cases were deemed to be an extension of the Bureau's authority rather than an enforcement of existing law. And it's also interesting to think about the way the Bureau is staffed or will be staffed in the future. Could they really have anticipated that they were going to be able to move forward with all of the cases that were filed towards the end of the last administration? So the list is here. As I indicated, there's a variety of different types of claims and types of financial institutions that were included here. But what I find almost even more interesting at this stage are the cases that the Bureau has indicated that they intend on proceeding with. And there are currently 4 cases that the CFPB has indicated they intend on proceeding with. As you'll see from the list below, they include alleged violations of the Military Lending Act and actions involving debt relief scams and predatory practices. These cases, from our perspective, appear consistent with some of the priorities that were set during the Trump administration's first term. And those include protection of military members. That was something that we've seen previously and something that I think we can all expect to see going forward. We also saw the pursuit of debt relief and credit repair scams or schemes. That's something that we saw under the past administration or the first Trump administration, and something that I think we can also expect to see moving forward. Now, we're also seeing activity and similar activity from the Department of Justice. And we are aware that the DOJ is investigating and pursuing SCRA actions. Thus, I think it's fair to say, as a takeaway, that the enforcement of laws protecting military members and their families is going to remain fertile ground for enforcement activity as we move forward under this administration. So one of the more interesting recent developments is the steps the CFPB has taken to unwind one of its prior consent orders that it entered into with Townstone Financial in November of 2024. Now, for those of you that don't know, the CFPB reached a settlement with Townstone Financial in a redlining case brought against the non-bank mortgage broker in November of 2024. And at a really high level, the CFPB had accused Townstone of discouraging minority applicants from applying for mortgages in the Chicago metropolitan area through derogatory statements that were made in podcasts and radio shows. The settlement required Townstone to pay a penalty to the CFPB's Victim Relief Fund and prohibited the mortgage lender from engaging in any actions that violate a code. In dismissing the case, the CFPB was highly critical of its enforcement staff and prior CFPB leadership for pursuing this case and claiming it used radical equity arguments to persecute and extort a small Midwest firm. So some really strong language coming out of the current Bureau. What's fascinating about this action is the fact that the CFPB is publicly reversing course, right? It's unwinding a final settlement agreement and publicly criticizing the enforcement action of the prior leadership. What's also interesting to think about from our perspective is this a one-off? And does the CFPB leadership intend to reopen other consent orders to right perceived past agency wrongs? I know that we've talked about this a lot internally. I know my colleagues are dying to jump in. So Marcy, Mike, you guys have some comments to make on this?
Yeah. Thanks, Ryan. We won't leave you hanging here. So it's fascinating, and sorry if I missed whether you said this or not, but Townstone, right? It was started under Kathy Kraninger. So, to date, our perspective has been that fair lending is nonpartisan. Like, we see a focus and a scrutiny on fair lending, notwithstanding whether there's a Republican in office or a Democrat in office. In this particular situation, the CFPB, when it moved to vacate the settlement agreement in court, it focused it focused largely on a free speech issue. So it didn't delve at all into whether the CFPB is changing course on its view of what the term applicant means under the Equal Credit Opportunity Act. So just to catch everybody up to speed quickly, the Equal Credit Opportunity Act defines applicant, or refers to applicant, and then in Reg B, that the way applicant has been implemented in that reg is to also include prospective applicants, right? So somebody walking down the street, ECOA protection, ECOA applies to that person walking down the street, meaning that advertisements and marketing, the protections of the Equal Credit Opportunity Act under the definition of prospective applicant would apply to her or him. And ultimately what Townstone at the Seventh Circuit said is that the CFPB had the statutory authority to define applicant to include prospective applicant, despite Loper-Bright, given that the CFPB has the right to craft regulations to make sure they're not evaded, right? And what is the other term, Mike? I'm searching for the concept. But the
convention.
Yes. Thank you. But the CFPB or the Seventh Circuit really hung its hat on that. So, both substantively we're left in a lurch, like, okay, well, is the CFPB changing its viewpoint on what it means? I mean, presumably not, because the reg still says prospective applicant. But, one of our themes has been like, stay the course, continue compliance, don't change your underwriting approach, because one, generally fair lending is nonpartisan, but two, the CFPB and more importantly here now, state AGs and consumer plaintiffs attorneys are still around.
And one thing I'll add to that is that if you look at the press release that the CFPB issued regarding the actual CFPB's act of working with Townstone to remove the settlement, they actually blame it on CFPB employees purportedly misleading the Bureau about the strength of its case altogether in order to further DEI goals. So I think that kind of solves two problems for the CFPB, or at least the current CFPB. One, the fact that, yes, the case was brought by a Republican Trump-era CFPB director, Kraninger, but the second, it does give them some wiggle room, right? If they see something that is so egregious or something that goes against some of the CFPB's kind of current goals, it's not necessarily saying, hey, we're not going to bring these kind of cases. We're just going to bring them in when the circumstances are correct.
It's sort of hard to imagine what could be more egregious than some of those statements that were alleged to have been said, though.
Oh, totally. Absolutely.
Yeah.
I tend to think that this is more likely than not. I agree with everything Marcy and Chris you just said. I mean, it's such a unique, it's been such a unique case, but also this new announcement seems so unique, at least certainly in the history of the CFPB. I tend to think of this as more likely to be an outlier or a one-off, to Ryan's point. The Townstone case, I'm trying to articulate this. The defense of Townstone from the very start has been very, very public, and it just seems to me that the themes related to the defense seem to be matching up very well with the policy goals and agenda of the new administration, and because obviously there's a lot more here related to DEI and all of the executive orders and the impacts of those executive orders. Some of the things that are happening with pressure on law firms to end DEI programs. So it does just seem like the acting leader of the director, as Chris mentioned, is also one of the architects of Project 2025. These are some of the larger policy goals of this individual and the administration, and the way that the defense has positioned their defense for the last several years really seems to almost be in lockstep with those goals. So in a sense, it's not a surprise to me that the CFPB would be sympathetic under their new leadership. What it is surprising to me that they would go the extra step and actually try to vacate the consent order, because as Ryan says, what kind of precedent does that send? Are we now in a space where other parties that have paid civil monetary penalties or even consumer redress can now just petition the CFPB for a refund? And what are the criteria that would govern that process? It seems to raise a lot of questions.
And does this lead to an unwinding of certain consent orders after changes in administration, right? Are we going to see this again as the administration continues to roll over during the various election cycles? So it's a really interesting case. It'll be interesting to see what happens as we move forward. So what else are we monitoring? Well, there are approximately 20 additional cases that remain pending with no indication of how the Bureau intends to proceed. The CFPB in these cases has either requested a stay to consider its options or has not made any public statements about its intent to proceed. So I expect the CFPB will dismiss many, if not all, the pending actions that were initiated under the prior administration, other than those potentially affecting discrete populations or matters identified by this administration as a priority, such as those involving service members, which we talked about, or where there's a procedural issue in a case that may make it difficult to dismiss. One case that I'm paying particular attention to is the Bureau's pending case against Experian for alleged violations of the FCRA. The court in this case denied the Bureau's motion to stay, and Experian has filed a motion to dismiss. So the Bureau is going to have to act quickly and spend resources if they're going to pursue this case. And under the last Trump administration, many of you will recall that the FCRA remained a priority. And given that FCRA compliance impacts a variety of our financial services clients, this will be a potential indicator from my perspective of what to expect as it relates to FCRA enforcement and perhaps FCRA supervision. At this point, consumer financial services companies are going to need to continue to monitor the dockets and filings in order to understand the CFPB's priorities. And as we go forward, I think it remains too early to tell on what the next 4 years will look like from an enforcement perspective. A couple other items to note before turning it back to my colleagues are, as we sit here today, we do not have any indication how the Bureau is going to proceed with supervision or what that supervision will look like as we go forward. For example, as we move forward, we don't know whether the Bureau will streamline its supervisory responsibilities and move away from on-site examinations. Certainly that would gain efficiencies and be consistent with more streamlined supervision that some are expecting, but we just don't know yet. Another item to note is we're hearing from clients that the Bureau is actually engaging in its market research function. And these have just recently begun. We have clients that recently had outreach by the Bureau to gather information on certain issues. And as many of you know, the Bureau does this when they are trying to understand a market or issues and assessing risk of a particular industry. And finally, we also understand that the consumer complaint division and responsibility is functioning. And we have at least one client that has received outreach from the Bureau on various consumer complaints that it received and follow up requests for information that her client is receiving. So that seems like a function that is starting to slowly come back. So with that, I'm going to turn it over to Marcy, who's going to discuss the Congressional Review Act resolution. And thanks so much.
Okay, thanks, Ryan. The Congressional Review Act. All right, so Congressional Review Act is relatively new. It was enacted in 1996 and really was not used heavily until Trump. So President George W. Bush used it once. President Trump used it 16 times in Trump 1.0. And then President Biden utilized the authority one time or 3 times. Here we have several Congressional Review Acts in the hopper. And there is a big impact once something has been, quote unquote, CRA'd. So what happens when a rule or regulation is CRA'd? So first, just the mechanics of it, it has to go through both houses, both the House and the Senate, and then it has to be signed into law by the president. When that happens, when a joint resolution of disapproval is enacted, the rule, if in effect, will go out of effect immediately. If it's not yet into effect, it will not go into effect. And I should clarify that there's only a certain time period within which a rule can be CRA'd. And that's 60, I think, legislative days. And there's some unique counting and calculations to it. So we can't go back and just like pull any rule that was promulgated by President Biden in the last 4 years. It has to fall within this particular period of time. Or alternatively, if it was promulgated before that 60 days, there was some procedural mishap that made it such that that 60 days didn't start clicking away. Assuming that you're within that 60 days and the regulation is CRA'd, it goes out of effect immediately or it doesn't take effect. But then, importantly, it cannot be reissued in substantially the same form. And a new rule that is substantially the same may not be issued unless Congress authorizes that by law. Importantly and critically, and something that someday maybe the courts will determine, is that the CRA does not define what substantially the same means. So that could be up for question, depending on what happens. And certainly we're seeing a lot of, litigious and litigation. So, okay, here in our space, you all might remember that the arbitration rule was a rule that was CRA'd. And that is a huge one for our clients. Many of our clients utilize arbitration agreements. It's often more beneficial for consumers. They get through the process much more quickly and get relief much more quickly. But that was CRA. So a substantially similar rule cannot now be promulgated by the CFPB. Another is the Indirect Auto Lending in Compliance with the Equal Credit Opportunity Act Bulletin. That is one of those that suffered from a procedural mishap. It was just a bulletin that was issued in 2013, I think. And then when President Trump came into office in 2016, it was CRA. So let's just kind of bop through. I'm looking at the time, so I want to just be quick here. Some CRA resolutions in the hopper, the digital payment app larger participant rule. And again, since we were delayed with technical difficulties, we can now announce that the House, both the Senate and the House, have approved the resolution, and it is expected to be signed by President Trump. Serious implications for the CFPB's future jurisdiction over big tech providers. So I should have started with this, larger participant rules. The CFPB has the ability to promulgate a larger participant rule that would then apply to those defined as a larger participant and would give the CFPB supervisory authority over those larger participants that the Dodd-Frank Act itself does not specifically articulate. All right, so the overdraft rule passed the Senate on March 27th, and then again approved by the House on April 9th. Here, there's a question of whether there could be some flexibility by the CFPB in the future to regulate overdraft practices. Here, the overdraft rule was issued by Reg Z authority, so could there be some way to regulate overdraft under a different statutory authority such as UDAP? The medical debt rule, this was introduced on March 11th, and as the slide notes, just really unclear whether the resolution has enough support for this passage. There is litigation around surrounding this rule too. All right, so we're not aware of other efforts to CRA any particular rule, but we certainly anticipate strongly that once McKernan is confirmed, they're going to continue to go through their rulemaking and policy docket and make changes. Other recent developments. Yeah, go ahead, Chris.
Yeah, absolutely. In terms of other developments, as a lot of us have seen, lots of things happening on top of the CRA issues and some of the changes with enforcement and supervision. And the first I want to talk about is, the rescission of the BNPL or buy now, pay later guidance. Now, there were a lot of things that kind of gave us pause and that we weren't sure whether the CFPB was going to do during the Trump administration. A pullback of the buy now, pay later interpretive rule was not one of them. I think we were pretty sure that the new CFPB would probably scrap that guidance. Now, recall that under former Director Chopra, the CFPB released guidance that buy now, pay later products, because some of them involved digital user accounts, meant that many buy now, pay later programs constituted credit cards. And this would have required that certain buy now, pay later products and providers comply with Regulation Z requirements, including providing account opening disclosures, billing statements, change in terms disclosures, liability for unauthorized use. They would comply with requirements related to merchant disputes, and then a lot of other things that would have caused a lot of problems and a lot of burdens on companies in the buy now, pay later space. And unsurprisingly, right after that guidance was issued, the Financial Technology Association, or the FTA, filed a lawsuit arguing that given the nature and extent of the changes that would have been required by this guidance, the CFPB violated the Administrative Procedure Act by not going through the notice and rulemaking process. They also argued that the new rule exceeded the Bureau's statutory authority. In March, the CFPB announced that it planned to revoke its buy now, pay later interpretive rule by way of a joint request for a stay in that litigation that had been filed in the DC District Court. So it looks like the Bureau is pulling back and rescinding that buy now, pay later guidance, which I know is happy news for the BNPL industry. We've already talked about Townstone Mortgage, so I'm not going to go over that again. The other thing that I think, again, pretty unsurprising, and that is that the CFPB has elected not to enforce the payday lending rule. In March, the CFPB issued a press release saying that it would not, quote, prioritize enforcement of the payday vehicle title in certain high-cost installment loans rule. That rule went into effect on March 30th. And according to the Bureau, it's going to focus on other areas such as protection for military veterans and personnel and small businesses. Now, this rule would have prohibited the practice of debiting a borrower's account after more than 2 attempts at withdrawing funds without a renewed ACH authorization. Now, because this rule had already gone final, it's a little bit more difficult for the Bureau to just pull that back altogether. So unlike the buy now, pay later guidance, which was just guidance that was issued, this actually is going to require the issuance of a new rulemaking to totally pull it back. So, and I think because of that, the Bureau stopped short of formally suspending the rule altogether, because arguably it would not be able to do so without a new rulemaking. So, I think that there is some consternation in the industry that hey, technically entities are still subject to the small dollar rule. So we do see that I think a lot of folks in the industry are still technically following that, and that's probably going to be the case until we see a new rulemaking occur. Similarly, on April 11th, a few days ago, the CFPB announced that it's not going to, and it used that same language, prioritize the enforcement or supervision activities with regards to entities that do not satisfy future deadlines under the regulation to submit registrant information under the non-bank enforcement action registry, right? So another instance where you have a rule that has gone final, but the Bureau has not actually entered a rulemaking stating that it is not going to, that is pulling back that rule. So yes, folks that are subject to the non-bank registry are still subject to that rule, but the Bureau has promised that it is not going to actually take action to enforce that rule as of today.
Chris, when I saw that news, one of the thoughts I had was, well, is there even going to be anybody at the CFPB processing those registrations? Like, are they,
right.
So they're not going to enforce it, but then if a company errs on the side of caution and makes a business decision that it wants to submit, what's going to happen on the other end?
And that's a good question. And I think, for folks that are out there that are actually have made that business decision that, hey, we are going to go ahead and comply, it would be interesting to see kind of what happens when you make that effort. Because I certainly have not seen it on my end. I don't know if anyone else has as well, but certainly would be interested to hear how things go on your end. And then the other thing to keep in mind, or that we've seen, is the 1071 rulemaking. I think that's another rule that has gone final, and there were compliance dates sitting out there, and a lot of folks in the industry have been working to, A, figure out, hey, are we subject to the 1071 rule, and B, do we have to still comply with that rule? For folks that might not be as familiar, 1071 is effectively the Home Mortgage Disclosure Act for small business finance companies. It requires certain entities that originate commercial finance products to collect and disclose over 80 pieces of data related to covered transactions. There's, again, lots of litigation that's been brought related to the 1071 rule, but the Bureau, in response to a motion to stay filed by the Revenue-Based Finance Coalition, stated that that leadership has, the CFPB has directed staff to initiate a new 1071 rulemaking, and that the CFPB anticipates an NPRM that would possibly solve some of the issues that are being litigated in that Fifth Circuit litigation. The actual stay that's been issued, the stays have been kind of piecemeal, right? So in some of the 1071 litigation, the stay related just to like the American Bankers Association's members, and then for the Revenue-Based Finance Coalition, they asked for a stay for all of its members. But the thing to keep in mind about the 1071 rule is that the scope of the 1071 rule is it's deceptively broad, and it includes entities other than just banks and merchant cash advance providers. So if you're not covered by the stays covering banks and merchant cash advance providers, you still need to be paying close attention to what the CFPB does in terms of the broader 1071 rule and how quickly they formally elect to pause the rule. So still a lot happening, a lot of uncertainty out there. And with that, I do want to give us a little bit of time to talk about, like, what is our post-transition forecast? What do we see happening here in the next few months?
Great, thanks, Chris. So we'll keep this really quick to respect your time, since we're 2 o'clock is 2 o'clock Eastern is upon us. So at least my view, maybe somewhat subjectively from being at the Bureau for a very long time and going through prior transitions, is one of cautious optimism. I wouldn't have said that in early February before NTU went to court. It did seem like for a little while there really was a real chance that the CFPB was going to be lopped off in terms of the number of employees to a very, very small entity that really couldn't do anything. And it does seem like either the force of the lawsuit itself, the Bureau's actions of the current leadership to kind of slowly turn the lights back on, literally and figuratively, to restart some of the functions, as Ryan alluded to, announce at least 4 or 5 of the enforcement actions are going to be moving forward while dismissing others. It seems like there is going to be, in my view, there's going to be an agency going forward. There are a lot of questions about the size of that agency and, of course, the priorities of that agency from a policy perspective. But at least from listening to the DC Circuit argument, the oral argument last week, 2 of the judges were appointed by President Trump during the first Trump term. One of them was very skeptical of the government's contentions about their ability to unwind the entire agency. So I think the order that I discussed earlier kind of reflects that view of splitting the baby. And combined with, as Marcy was saying, McKernan has a reputation of being independent, kind of pragmatic, dating back to the FDIC. I am hopeful that there will be kind of a return to normalcy, and there will be it's different from when I was there in 2017. None of this really seemed on the table in terms of these more dramatic changes, but perhaps after a longer fraught period, things will reset. There obviously is going to be a change in policy priorities. Chris alluded to some of the things already happening. Marcy did as well. The last point I wanted to mention, though, is that is a little bit of a counter, and Marcy alluded to this earlier. McKernan reports to the president, and the president has signed some executive orders recently, including one last week, that really kind of cracks down on the independence of so-called independent agencies. And they are trying to take some actions legally to really assert executive control over independent agencies, including ordering them to basically revoke a number of federal regulations that, in the agency's view, do not comply with Loper-Bright and certain other Supreme Court cases. So there could be a tension going forward between some of all this drama kind of stopping, McKernan getting confirmed and coming in, but there still could be a rather outsized influence potentially from the White House. But that just might be a function of where we are post-Celia law with the CFPB. So with that, I'll let Marcy take it home.
Oh, not doing the poll question quite yet. Okay, so I recently had an op-ed that appeared in the American Banker, and my view is that there were good law-abiding companies that were caught in the crosshairs of Chopra's take no prisoners approach. And I think as a result, the agency had a big target on its back when President Trump came into office again. My view is that the CFPB has a unique opportunity now to course correct and make announcements and pronouncements in its course correction to make sure that those good law-abiding companies that were caught in the crosshair, that it is known that the prior CFPB administration undertook overzealous efforts that were not consistent with applicable law. But the point being that the CFPB has an opportunity to offer a reasonable and stabilizing voice, and that the rules and laws that apply to this industry at both the state and federal levels will be there, whether the CFPB is hyper-functioning or whether its functions are significantly reduced. And so the CFPB has the opportunity to clear that slate, and working with Congress set clear guardrails for the CFPB. But as importantly, the agency must continue to heed its statutory authorities and strike a healthy balance between consumer protection and innovation, credit access, and competition. So a lot remains to be seen. Thanks for sticking with us these last few minutes. Let me just put up this poll for those that need continuing education requirements or polls for it. Note that will not affect your ability to get CLE if you dropped off. But let's just see, how will the CFPB emerge after the transition? Functional but lighter and less aggressive, non-functional. give you guys a few seconds for anybody who's still hanging around. We'll just go. All right. Functional, but lighter and less aggressive, and non-functional. All right. Well, we really appreciate your time today. Just a few housekeeping items. First of all, if you're not on our listserv, please see this QR code and sign up. We'd love to have you be a part of it, and you can get all the news that we release, all the alerts we release. As a reminder, the program has been approved for legal education hours. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Please be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. And thanks again. We really appreciate you being here. This concludes our webinar. Have a great day.